Supreme Court of India. Satbir Singh vs. Rajesh Kumar and others. Decided on April 1, 2025. 20,250 INSC 416. Facts of the case. On February 9, 2020, accused Mukesh and the appellant were admitted in Civil Hospital and Ram Chandra Memorial Hospital respectively, due to injuries received in an assault. FIR was registered. The allegations of Mukesh against the appellant were not substantiated and, ultimately, submitted a closure report. A cross case under Section 323, 324, 307, 506/34 IPC was registered against Mukesh and Rajesh, Neeraj, Sagar at Bit 2, and Ankit. The investigating officer did not find the involvement of Rajesh and Ankit. Charges under Section 324, 307 and 506 IPC and Section 25 of the Arms Act were framed against Mukesh. The appellant as prosecution witness 1 was examined. He reiterated the allegations against Mukesh as also against Rajesh, Neeraj, Sagar at Bit 2, and Ankit in his examination in chief. An application under Section 319 Cr.Pc for summoning Rajesh, Neeraj, Sagar at Bit 2, and Ankit to face trial, that succeeded before the sessions judge. The High Court set aside the order. Findings of the court. The law on the point of summoning additional accused and exercise of power conferred by Section 319 Cr.Pc is well settled. One may profitably refer to and rely on the Constitution Bench decision of this court in Hardeep Singh v. State of Punjab, 2014, 3 SCC 92, where law has been authoritatively declared in Dharampal case 2014 3 SCC 306. The Constitution Bench has already held that after committal, cognizance of an offense can be taken against a person not named as an accused but against whom materials are available from the papers filed by the police after completion of the investigation. Such cognizance can be taken under Section 193 Cr.Pc and the sessions judge need not wait till evidence under Section 319 Cr.Pc becomes available for summoning an additional accused. Section 319 Cr.Pc, significantly, uses two expressions that have to be taken note of, i.e., 1. Inquiry, 2. Trial. As a trial commences after framing of charge, an inquiry can only be understood to be a pre-trial inquiry. Inquiries under Sections 200, 201, 202 Cr.Pc, and under Section 398 Cr.Pc are species of the inquiry contemplated by Section 319 Cr.Pc. Materials coming before the court in course of such inquiries can be used for corroboration of the evidence recorded in the court after the trial commences, for the exercise of power under Section 319 Cr.Pc, and also to add an accused whose name has been shown in column 2 of the charge sheet. In view of the above position, the word evidence in Section 319 Cr.Pc has to be broadly understood and not literally, i.e. as evidence brought during a trial, considering the fact that under Section 319 Cr.Pc, a person against whom material is disclosed is only summoned to face the trial, and in such an event under Section 319 for Cr.Pc the proceeding against such person is to commence from the stage of taking of cognizance. The court need not wait for the evidence against the accused proposed to be summoned to be tested by cross-examination, though under Section 319 for b. Cr.Pc the accused subsequently impleaded is to be treated as if he had been an accused when the court initially took cognizance of the offense. The degree of satisfaction that will be required for summoning a person under Section 319 Cr.Pc would be the same as for framing a charge. A person not named in the FIR, or a person though named in the FIR but has not been charge sheeted, or a person who has been discharged can be summoned under Section 319 Cr.Pc provided from the evidence it appears that such person can be tried along with the accused already facing trial. However, insofar as an accused who has been discharged is concerned, the requirement of Sections 300 and 398 Cr.Pc has to be complied with before he can be summoned afresh. The sessions judge formed the requisite satisfaction bearing in mind the decision in Hardeep Singh and held that the tests laid down therein were squarely met. Reading the impugned order in its entirety, we are of the considered opinion that the High Court failed to consider the matter from the proper perspective and arrived at an entirely wrong conclusion. We have no hesitation to hold that the conclusion of the sessions judge was a plausible conclusion, and not an absurd. The impugned order of the High Court stands set aside and that of the sessions judge is restored. The appeal is, accordingly, allowed.